for coming today. This is joining us for another Breakfast Briefs. Today we have an interesting topic. I think you're going to like it. Before we get going, I just want to kind of go through a few things. First of all, I'm Ted McGinn. I'm with the firm Lavelle Law, the managing partner here. And Lavelle Law, we're a full-service law firm. We have our main office in Schaumburg. We also have an office downtown in Chicago. We handle a wide range of different legal services. I work in the business law area, which we handle business formation, shareholder agreements, operating agreements, a whole range of M&A transactions. Beyond that, we have a very busy estate planning group where we can handle anything from the basic, simple will, trust, power of attorneys, on up to the more complicated plans that handle estate and gift tax issues. We have a very busy litigation practice, handle all sorts of litigation, commercial matters, family law, including divorce, custody issues, condo litigation, which we'll hear about that a little bit probably. Real estate too. We do residential and commercial real estate. So, we can handle a lot of things. So, and anybody looking for a second opinion or want to talk to an attorney, we always provide a free initial consultation for new clients. There is a little slip, I think, before you. So if anybody's interested in meeting with an attorney on any topic, feel free to reach out to us. We'll coordinate and schedule that meeting. Also, restrooms are outside to the right. And before I turn it over to our speakers, just want to let you know, if you have questions throughout the presentation, feel free, don't be shy, raise your hand. They'd like to handle the questions as they occur to you. So we're not going to just go ahead and don't be shy. So today, one thing, we have Stephen Day and Robin Kirsch. They joined our firm a couple of months ago, so very excited to have them join us. It's been a great transition. Their team has been excellent, and they bring over a couple of different practice areas to us that's kind of new to us. Homeowners, condo matters, which we're going to talk about today. In addition, banking, foreclosure work. And so I'm going to, with that being said, I'm going to turn it over to Stephen.
Thanks, Ted. Yep. Steve Dady and Robin Kish, thank you for coming. There's some old friends here. There's some new friends here. I wanted to mention that it's kind of a wide range. We have board members from Arlington Heights, Palatine, Schaumburg, property managers from Arlington Heights, and some banks. But we've got Community Advantage, which is a division of Wintrust. They do a lot of condo loans. Itasca Bank and Trust, and Fifth Third. And I'm going to ask them a couple of questions later on to get into it. So there's board members, there's owners, there's a lot of people who are interested in this area of the law. So Robin, she'll give you a background of hers, which is immense in terms of this area of the law. So I've been in practice here in the Northwest suburbs for 45 years. My main area are condos and mortgage foreclosures. I represent a lot of banks. We do a lot of real estate litigation. We just joined the firm in September, and it's been a really great opportunity for us because it really broadens our areas of expertise and we can do a lot more for our clients, which I think is great. I don't know, without further ado, I'll turn it over to Robin. She can give you a little bit more background, and I'll hand the clicker here.
Hi, like I said, I'm Robin Kish. I've been practicing almost exclusively in condo, HOA law for over 16 years now. So I'm kind of an expert in it. There's always new things coming up, of course. So we always try to stay up to date and then share all that information with clients or anyone if they have questions. They can always reach out. So the first topic so we're going to cover a number of different topics here. We talk about assessment enforcement and legal updates. And then Steve is going to talk about litigation and project financing. As he said, if any questions come up, please just feel free to raise your hand so we can address them. So the first topic that I am going to talk about is this. There's the introduction, but he gave the introduction about it, so it's all good. So I'm going to talk about assessment enforcement, basically what an association can do when an owner fails to pay assessments. The first part is it's important for every association to have a collection policy. You want something in writing that lets the owners know what would happen if they fail to pay assessments. And it also makes it easier on the board so they don't have to take a vote every time they want to turn an account over for collections. So it's just best if you have a written policy. And then at a minimum, the policy should provide when assessments are due, when late fees are assessed and how much, when an account will be referred to an attorney for collections. And it should also let the owners know so they're aware that they are responsible for all the fees and costs related to that collection. And that way they have all of the information. Hopefully I don't go into assessments. But someone always does. So one way to start collections is to record a lien against an owner's property. The Condo Act actually gives an automatic lien under Section 9G1. So condo associations don't necessarily have to record a lien, but there's not a similar provision in SECA, the Common Interest Community Association Act. So HOAs, anyone non-condo would need to record that lien.
Robin, what's a community interest association and organization?
So community association kind of covers everyone that isn't a condo. There can be townhomes, homeowners associations, property owners associations, kind of everything that doesn't fall under the condos. There are certain requirements to fall under the Common Interest Community Act, or SECA as we call it. And that kind of depends on the association, but most associations that have more than $100,000 in common expenses would qualify. So it covers usually most of the associations. Okay, so the lien doc is then recorded with the county reporter. Some places like Cook, it's called clerk's office. But it's all there and you record it actually against the owner's unit, condo unit or home. And that gives notice to anyone out there that can check the public records of what is owed. And then if you do record that lien, you can actually foreclose it, the association can. If they want to take this step, a Condo Act has to actually record the lien before they can foreclose. But basically, they'll file suit and bring an action to have the property and force the sale of the property so that the association can recoup the outstanding amounts. The association also has the right to bid on the unit at the foreclosure sale. That often requires an owner's vote. So you should refer to your declaration so that you're certain.
Robin, can I jump in there?
Sure.
So the reason why this is not frequently used is because it takes a long time. So in addition to having to give all the notice, it requires filing a complaint, getting the person served by the sheriff or the process server. The court process takes for a long time. So you're talking probably a minimum of 2 years if you're going to foreclose, particularly in Cook County. At Cook County, it could take even longer. To pay some of the other collar counties less, but still it's very frequently used. It is used occasionally. We actually have had a couple up in McHenry County where we've done that, but like I said, that's a little bit different story, and that's not a condo association. So that's the community interest association that we're acting on behalf of. But that's why it's not frequently used.
Right. Yes.
I'm sorry, is that the same as a right of first refusal if an association could bid on it?
It's not quite the same thing. Some declarations give the board the right of first refusal. I mentioned, discuss that a little bit, but this is actually, they're filing suit to actually force the sale of the property in litigation.
So it's similar to a mortgage foreclosure.
Yeah,
Right.
thanks.
If the association does take the property, if they're the winning bidder at the sale, and then a judicial deed is entered, the association will take that subject to the owner's mortgage and any liens that were recorded prior to your lien or for condo acts prior to when the first assessment was passed due. As Steve said, it's infrequently used, it's long, and It's very expensive. So Illinois actually has a more efficient process to do. It is actually unique to Illinois. It's the only state that allows it. But it's often an easier process because it only takes temporary possession instead of permanent ownership. So that the association gets to lease that unit to a tenant, and then they can rent it for up to 13 months, and they can extend that if necessary, but it doesn't take the property away, so it's more efficient and it's faster and much less costly, unless you have a very contentious unit owner. Then sometimes the prices can rise, but typically it's much less costly litigation.
And what that is the owner still owns the property, but they can't live there. So the sheriff would come in and essentially evict them, which would allow the association to lease the property. And we've done that a lot. I think it's a method of recouping past due assessments. You can also include things like remediation for the unit in many instances. And so I think it's a pretty good situation, particularly because if you're not paying your assessments, you're probably not paying your mortgage either. So the bank is probably also foreclosing at the same time, which again, similarly, it takes forever to foreclose in Cook County. So it's a much easier, much faster process. You can hold on to the property and lease it until the bank then steps in and takes ownership. So.
Right, and as he said, you take it for temporary possession, and that's the place. It allows you to use it while the owner retains ownership, so that they're still responsible for the mortgage. The association doesn't take that burden on. There are 4 steps to the eviction action. Basically, there's the demand, and then the eviction lawsuit, and the actual physical eviction, and then the last step is leasing to a tenant. That step is important because all of that doesn't really get paid, unless sometimes the owners do pay, but otherwise, if you don't lease it to the tenant, then you're not recouping any money. So the first step is called the 30-day notice and demand. Typically, people refer to it as the 30-day notice. Basically, it's what advises the owner what is owed, and it gives them time to pay that. It's actually required under the law, so it's always the first step for collection. It's usually done by an attorney, but there are some management companies that do handle that part. So long as it complies with the law, it really doesn't matter who sends it. And then the demand has certain requirements set under the law, and it has to be sent to the owner of record. That's the actual name or names that appear on the deed. Sometimes a property could be held in trust. So even though you have the trustee's name, John Smith, you have to name the trust as well. Otherwise, you're not getting, you're not going to succeed in the lawsuit.
And that's why you would normally get a tract search to determine from the title company, search the title to determine that, because sometimes it's not very obvious.
And then the demand has to be sent to the last address that the owner has provided the association. It can't be just sent to the unit unless the owner lives there. But I always recommend that you also send a copy to the unit, meaning unknown occupants or owners, just in case something pops up, and that allows you to always get possession of the unit if you've named everyone. And you have to serve them first. It has to state the date of delinquency. So that it would be the first time that the assessment was late or the unpaid fine. Whatever started this delinquency, you have to include that time period in the notice. And then you have to state the full amount. That's all assessments, special assessments, any unpaid fines or other common expenses, late fees. And it can also include the attorney's fees and costs for sending the letter. So all that should be stated, because once it's sent out, the owner remits that payment in full at that time, then there's nothing else owed as of the date of demand. And then It has to provide at least 30 days to pay. Some associations or your declaration may require a longer one. That's more typically in homeowners association or property owners association. But it can require a longer time, so it's always important to check your documents. But you have to give them at least 30 days under the law. And then once that 30 days has expired, take the next step, which is the actual eviction lawsuit. That's the filing of a case to get that judgment so that you can take possession. And in Illinois, it has to be filed by an attorney. Since an association is a corporation, they have to be represented by an attorney in court. So even if the property manager submits a demand, you still have to make sure that this part is taken over by the attorney. And then, so the first step to a lawsuit is when you file the actual case. You file the complaint, to let the court know and the owner what exactly is owed and what you're seeking. What you're seeking is both a money judgment for all past due amounts, including attorney's fees and costs. And then you also are looking for an order to take possession of that unit. After the case is filed, you have to serve the owners and all occupants of the property. This gives them notice to come to court. Then once they're served, you're going to see the eviction order. That's the order by the court that says they have to pay the amount, and that if they don't pay the amounts within the time frame, they could be evicted from their home.
What if they're renting the owner's renting the unit?
The owner's renting the unit, there are two options. If you name them in the lawsuit, you can actually evict the tenant depending on certain criteria, but mostly what happens is you also seek an assignment of rents, which basically gives the association the right, once that stay expires, to collect rent directly from the tenant. So that way, instead of having to find your own tenant, you can just basically take over the lease to collect that rent directly from the tenant that's already in the property. Makes things much easier usually, but there are some pitfalls because sometimes the tenants have difficulty understanding the process and remembering that the rent has to go to the association rather than the landlord. And then when the eviction order is entered, like I said, there's an order for possession entered as well. Under the law, is always stayed for at least 60 days. The court can actually extend that all the way up to 180 days to give the owner time to pay the judgment off before you can take another step. Typically, it's 60 days, sometime in extreme circumstances. There's elderly occupants that might need senior services, or there's attorneys. Sometimes if the defendant is coming into the owner is coming into money, the court may give them a little more time to pay, but that's usually only 90 days. I had an extreme circumstance one time with an elderly woman, and that was 120 days, but I've never seen longer than that unless the parties agree. So sometimes the association can enter into a payment plan or some other kind of arrangement with the owner and agree to give them that more time to pay. But otherwise, it's usually 60 days.
Robin, how long from the demand to the actual tariff lockout typically does it take, say in Cook County? I think that most of the people are in Cook County.
Yes, so Cook County is very owner and occupant friendly. So it's always a long process because they have things set up oddly in the courthouse. And I've actually seen a couple other counties who are kind of following suit a bit. So what they do is they give you an initial courtroom to go in once you first file the case. And then depending on how long it can take you to serve an owner, if you can get them served before the first court date, that's great, but it doesn't usually happen. So you have to serve the owner notice, and it usually takes 3 court dates in Cook County. It's a little easier in other counties, but you have to give them, well, you don't have to use the sheriff anymore, which is good, because originally there was a law that required you to make first attempts with the Cook County Sheriff, and they only go out once. So they don't often obtain service. So what we suggest is that you use process server. They usually go out multiple times at different periods of the day and even the night to try to get notice to the owners. So some people work or maybe they're not there for a few days, but they'll go back to try to get them service. And the final one is if you don't get service in person, if you can't actually have someone physically give the documents to someone occupying the property, the law allows you to serve them by posting, which sounds like you posted on the house, but that's not actually how it works. You serve to submit the documents to the sheriff of the county, and then they post it in 3 public areas, usually the courthouse, the sheriff's office, and then Cook County uses, I think, the clerk's office. But what they do is then they post that and then mail a copy to the property. And that counts as valid service, so the owner has to come to court. If you do serve them by posting, you can't get a judgment against the owner.
For money.
Right, for money. You still get the order for possession, but you also get a money judgment against the unit itself, since it's based on you, under the declaration, it's a lien against the property. So it really works out to be the same thing. It still allows you to take possession and then be.
And how much typically does it cost for the eviction process? If it's a default situation, in other words, nobody comes in, you serve everybody timely, and there's no attorneys that get involved. They don't file anything. They don't ask for a jury, which then sets it to a different level.
Right, so there's actually 3 ways that you can get an eviction order. The first is, as Steve said, by default. That means you serve the owner, no one comes to court to fight, and then in Cook County, you still have to give them another opportunity to come to court, but it would only take another month or so to get the judgment order. So if everything goes very smoothly, usually, but if it goes very smoothly, it would take 4 months for the whole process, 5 or 6 usually. And then it's another, at least 60 days before you can take possession. But we'll talk about that in a minute. If they do show up in court, then you would either need to seek an agreement with the owner. That's typically when payment plans come into play or more time or something. It's always faster if you can get the owner to agree to the amounts and then the entry of the order. If the owner comes and won't agree to the amounts or won't agree to the time frame, you have to have a trial. That typically really extends the process because the county is so far behind everything that it typically takes a month and a half to 2 months to get a trial date before you can bring the case. And at the trial, what you do is the attorney will present the association's evidence. Typically, it's the property manager that appears to testify. If there is no property manager, then one of the board members would need to come and testify. Basically, at that time, you review the declarations as the basis for the money owed. Then you go through all the amounts that are owed. If there are unpaid fines, you also have to bring in the rules and all notices sent to the owner, just to show the court that you followed the proper process. And then at that time, the owner can present any defense. It really isn't a defense to owing the condo association, but they always try to come up with something, or at least share their sob story, which unfortunately some of them are in very dire straits, but the law doesn't really care because you have to pay your association because you're not just paying on behalf of yourself, or you're helping fund everything that the association is responsible for. So if one owner falls significantly behind, that can really affect how the association operates.
That's
Yeah. Okay, so once you have, I'm sorry, you asked about the time. So like I said, if you have to go to trial in Cook County, you're looking at a minimum of 8 months just to get that order. Sometimes they take a little longer, but typically they're done before a year. The courts are looking to push these through in 6 months, but due to the volume of cases before them, they're really looking to make sure it's off the calendar in a year. So they want some kind of resolution by then. Which is why I said it's always easier if they don't show up. If they do show up, to get an agreement. So you have to go through the whole trial process. It's going to make everything longer and more expensive. Typically, a default eviction, so when no one shows up and fights, it's about $1,200-$1,300. But once they add in that trial and things like that, you're talking about you go up to $2,000 or more. So I always recommend that the associations do everything they can to try to work a bit with the owner so that you can get it resolved.
And short houses handle those cases.
So in Cook County, each of the 6 courthouses will handle the ones in their jurisdiction. So when you're filing against a property, you have to file at the courthouse where the property lies. So if you're here in Palatine or Schaumburg, you have to file at the Rolling Meadows courthouse. Gives the defendant or the owner proximity so they can get to court. Okay, so once you have the order and the stay has expired, the next process is actually, next step is actually evicting the occupants of the property. So this involves, that doesn't mean the association can just go in and kick everybody out and say, now the property is ours.
Change the locks.
Right, change the locks, or turn off utilities, anything like that. There's no self-help in Illinois, which means you need to actually use the county sheriff to do the physical removal of the occupants. So the first step there is you place the documents with the sheriff. The county again is behind, the sheriff's very behind, and unfortunately we're coming to the winter, which means there's also a moratorium in place during the holidays. And then anytime that it's colder than 40 degrees, they won't come out and evict. So if your eviction falls on that date, they're going to reschedule it and you have to do it again. So what happens is once you place those documents with the sheriff, kind of just in waiting pattern, and so the sheriff sets a date and then they'll send you notice. It typically takes a couple of months at least before they schedule the eviction. And they'll give just the association notice. So before they schedule the eviction, they will notify the tenant that the eviction is pending, or the occupant that the eviction is pending, so that they know it's coming. But they don't tell them the actual date of eviction. This is actually for the safety of the officers. So they don't show up and someone has a gun or something to try to keep them off the property. So they always ask the association not to inform the occupant of the actual date of the eviction.
The other thing is we only get 24 hours. So if the sheriff's coming out on a Friday, they call about 3 o'clock on Thursday, and the property manager, Dennis would know this, you have to have your locksmith, your movers, people to handle, because the sheriff just goes in and so if they're there and they open the door, then they would just go in and tell them. If they're not there, they bust down the door. If you've ever seen that, it's a pretty amazing process, but you have to have people there. Otherwise, and if you don't meet them there at the time that they say that they're going to be there, and they get like a 4-hour window, they leave. So it's kind of it's a mess, but
You go to the bottom of the list.
and you go to the bottom of the list, right? And I think they run these things out of Maywood. So, it could, like I say, if you go to the bottom of the list, then it's a big problem.
We covered some of what I was going to say, but basically, once the eviction date is set, then the property manager or board member has to meet the sheriff there. They don't tell you when to come. They give you a 4-hour window, and you just have to have someone waiting there to meet them when they show up. And then you have to get out of your car or home, wherever they're meeting you at, if you live nearby. Like you can see the property from your house. You have to go out and walk up to their vehicle. Otherwise, they'll sit there for 5 minutes maybe, and then they'll just pull away. And then that means filing and waiting, then nothing, and you kind of have to start the whole eviction process. So not the court case part, but the actual physical eviction over, we have to pay the fee and wait for them to schedule a new date. So it's important that there's someone there on time, and then you just gotta wait. Actually, Cook County doesn't have a better system, so that's what you gotta do. And then,
Just a quick aside. So getting back to the case, one of the things that is somewhat of a defense is the association has to keep records and a ledger of payments so that you can present that to the judge, because if it's challenged, if the owner comes in and says, hey, I made these payments, or that's not the right amount, then that's what generates the trial. So I think it's important for property managers and board members to make sure that, your treasurer and your property manager keeps accurate records of the payments and also any fines. So assessments, fines, other charges. So you can prove it up in court.
right, and that's why you need to make sure that you have those documents as evidence, make sure that you have your governing documents, know where they are, so that they can be used in court as well. So then, once the sheriff is evicted, so when the sheriff comes, they will evict the people. They don't remove the property. It's the association's responsibility to either hire movers or change the locks and lock the door. You have to give some time for the owner to remove their possessions if they need them. But then you can either move the items out, which is not recommended, because if something happens to those, that the owner's personal property, they're going to turn around and sue the association. So what we typically recommend is that you hold on to those possessions for a reasonable time. What a reasonable time means, nobody really knows. But I would say that at least several weeks to try to arrange time with the owner to come and get the rest of their possessions out. It's important to remember that if the owner does come back after that eviction, someone from the board or the property manager has to be with them at the whole time. Otherwise, they can take possession back. And unfortunately, even if you called the police, like Schaumburg Police or something, they don't get involved in any issues of possession. So you would need to bring it to the sheriff again and you have to start over again, because once you evict on an order, it's not valid anymore. So that's why it's always important to make sure you never leave the owner or the occupants in the property alone after the eviction. Okay.
Next.
Okay. So once the association has possession of the unit, the board or the property manager needs to go inside and see the condition, check whatever's needed to actually make that unit rentable. Sometimes appliances don't work or they're missing, there could be damage. And then what the association can do is actually address those needs. I mean, reasonably, you can't put in like a jacuzzi or something, but you can replace broken appliances, you can paint, replace carpeting, all of those things to make it appealable to a tenant. And then the association gets to recoup reasonable expenses for that from the owner before they get possession back. So then when you lease to the tenant, you want to make sure that you get a written lease. It has to be in writing and set out all the terms. There should be a notice provision in there as well, where you can end the lease with 30 or 60 days notice. But because once the owner is paid, they have the right to take possession back. They have to wait until the end of the lease. But any rent you collect has to be returned then to the owner once it's all paid. And the way that the rent is applied to the account is first you have to pay off the whole judgment amount. That's where it goes to. So whatever the court ordered, all those attorney's fees, all of that needs to be paid off fully. And then once that's been taken care of, you get to apply the payments to the expenses that you incurred by making that unit rentable. And then finally, it's applied to the current assessment. So anything that came due after the judgment was entered. And not until all of that is paid off and the lease is expired, can the owner get it back. And then once you enter the lease, it has to be for a term of no more than 13 months. And it has to be entered within 8 months of getting possession. So you have some time frame to find a tenant, but you have to make sure that you're working on it relatively quickly because it can take time to fix the unit, to find a tenant and enter into a lease and all of that. And you can then have a term for 13 months, so usually it's a year. You can extend that longer if you need to, but you have to go to court to get the permission from the court to keep going. And then they're gonna look at all of the rent collected, how it was applied, and see if there's still amounts owed. And then they'll let you enter into another 13-month lease. Typically, it's paid off in a year because you don't want to let the expense to get that far behind. We typically recommend that you start the process at 60 days, maybe 90, depending on the association. If it's a quarterly assessment or even a yearly assessment, you're going to wait a little longer because it's a less amount that you want. But if you wait too long and it builds up too much, it's going to affect the association and take longer to collect. Then the associations are responsible for that tenant in the unit. So that's why we recommend to start the process early. Anybody have any questions about that?
Actually, I do. First of all, if you're renting to someone, as a tenant, is it the board's responsibility to tell the tenant this is going under evictions and all this kind of stuff, or you don't have to tell them that?
You don't have to inform them that.
Right.
But you should make them aware that it is not a long-term lease.
Okay, but you don't have to tell them this is going through the board system and down that.
You don't have to tell them that information, that's fine.
So if there's a foreclosure pending, which is why I'm suggesting a notice provision, if the bank takes it back,
Right.
then, you got to, they'll kick the person out. So you want to
So it's probably better to
tell them, I would say that's probably better.
okay,
If there's a foreclosure pending though, you do have to advise them.
okay.
That's required. And that's why you want to give them notice or have that provision in there, because as soon as the sale is approved, so if the mortgage lender takes the property back in their foreclosure and get that order from the court, the association can't collect rent anymore because it's not the new owner's responsibility. Technically, the new owner is responsible going back to the date of the sale, but nobody pays until it's approved. So it's a little gray. There's a possibility the owner could pay it off and keep the property, so you can keep collecting rent until it's approved.
Question. I apologize for the single family. Doesn't sound like this is something that you have. Election. It's the same kind of recourse. I got the single family. It sounds like this is more general.
It isn't just for condos. It does depend on your declaration. And that's why it's important to have that collection policy too. But homeowners associations, townhome associations, anyone has the right to use this. With homeowners or property owners where there's like not monthly dues or assessments, I don't do this dues, but assessments, then it usually takes longer to start the process. Because if they just missed one quarter, kind of jumping the gun to take the court, take possession for that little amount. It's going to grow and get the attorney's fees and costs in there, but it's not significant enough usually to take possession of the property. It's always good though to send the demand. Sometimes just that notice that they have this time frame to pay or they're going to be evicted from their home, which a lot of owners don't know about. That gets them to pay anyway, especially if that letter comes from an attorney.
They brought up to that edge. They played that game for years. You can see it on that in their rights to do that to us, or
Yeah.
we sound scary.
Right.
Well, you got to follow the statute and your declarations. So, that's where it all comes into play. The Community Interest Association, which is probably what you're talking about, has slightly different rules, but basically the same. if it happens. We've used that before in a couple of associations up in Kevin County and others in Cook County, but it's a similar process. The notice provision basically have to be the same. It's a little bit different.
And if it's a frequent happening, then that might be the time where the association needs to take a stand and take them to court, even though they only know 1 year's assessment. And then they become responsible for all those attorney's fees and costs, and I guarantee you they never do it again.
I'll get a question back.
So I'm an association with their absentee owner of the first time to possession. Organized. We're the police on there.
It doesn't matter whether they're there or not. Still have to go through the whole process. At that point, you really need to consult the association's attorney. Get questions about this frequently. Technically, there's no South in Illinois, so the best process to be sure is the sheriff. You could also try to contact the owner because they may voluntarily turn over possession. That usually happens kind of when it's a deceased owner or an absentee owner who lives elsewhere. They may just agree for the association to take possession and rent it out. But if not, then you go through the sheriff's process and you take possession just the same way, whether they're there or not.
Mr. Hughes.
It doesn't matter how much money they owe, it's your collection policy. Right. And once they're 60 days, if that's what your collection policy, it doesn't matter if it's $10.
It doesn't. You can do it at any point. And again, once the attorney's fees are added up, it's going to be longer, but you have that point where you're going to reach everything gets paid off. And then you're crediting the rent to the account. And then the owner can request an actual payment of that. So we recommend it usually gets a little more than $10. But anytime your collection policy, whatever your collection policy states, if you follow that, you're fine.
And I mean, our experience has been that about 95% of owners pay off the 30-day demand. So if they get a 30-day demand that they don't pay off, but usually they pay off before you get into all this other stuff.
Right.
If you're getting it early.
Right. I mean, as soon as they get notice that they could be evicted from the home, a lot of them pay. We always say that it's a little scarier to get the letter from the attorney, but many property managers handle that part, and that's fine as long as it complies with the law. Anyone can send that letter.
So any other questions until now? Go ahead.
You mentioned that the attorney's fees, if they do take it for the environment or splitting those fees, that's what's happening.
There's no splitting, they pay. They pay.
Under your declaration, it will say that the delinquent owner should state your collection policy as well. The delinquent owner is responsible for reasonable attorney fees and costs. So they have to pay those as part of paying off the judgment and getting possession back. And some owners also, I didn't mention, I'm sorry, some owners will pay within that stay period, so they don't lose the actual possession of the home. And as long as they paid everything off, including all current assessments, then the eviction order is void and possession. It's only if they don't pay that you take that actually evicted.
Okay, so we want to kind of enter on time. So I think Ron is going to relatively quickly through some of the legislative updates, but I also want to recognize a couple people here. Sam, he's been responsible for setting up the room, getting coffee and everything. So Sam is a Lavelle employee and he does an awesome job. So let's hear it for Sam. And Jackie is our marketing coordinator here at Lavelle, and she set this up, and she's probably the person who you got the emails from. So let's hear from Jackie. She actually coordinated the headshots that we took, which you saw earlier, which I think are pretty good. You know, it could have used a little darkening of the hair. But that's okay. So Robin, why don't you kind of move through? We've got, because I want to talk to, I think some people want to hear from some of these bankers a little bit about loans and stuff and some of the financing options. So if we can kind of move through the legislative updates and hit the highlights. And I think there's going to be some more questions about declarations and some other general condominium type issues. So.
So the next step, I was going to talk to you about recent changes in the law or new laws that have been passed that affect condos or common interest community associations. The first one is actually a new section that was recently added to the Condo Act. It became effective on January 1st of this year, and it requires boards of associations with parking to adopt a written policy to address a disabled owner's request for accessible parking. It has to, so that policy kind of depends on what kind of parking it is, but all policies must state the time frame in which the board or the property manager will respond to that initial request from the owner. And that time frame cannot exceed 45 days. So it's important once you get a hold of that to make sure that you're addressing that request. So if the association has common element parking that's available for all owners to use, then what you need to do is give disabled owners priority for spaces. That's why you usually set up handicap spaces so that they have those. If it comes to you and says, I need an accessible space, but there's never a handicap space when I get here, consider putting another one in for their use. If, however, the parking is either deeded to the owner or it's a limited common element that's actually assigned to their unit, it's kind of a trickier process because then what the board is required to do is to try to facilitate an exchange between the disabled owner looking for that accessible space to exchange their space with another owner. It's not something that you have to force, but you have to make reasonable efforts to try to get that to work somehow. The deadline to actually adopt the policy was April 1st. So if your association hasn't done so yet, I recommend that you jump on that. Then the next one, I was going to talk something, but please look quick if you have questions, you can stop me. The next one is about discriminatory sales on behalf of the board. Is what this is. So about a couple of years ago, a new section was added to the Condo Act, 22.2, and it prohibited an association from using its right of first refusal, option to purchase, any right that you get under the declaration to block a sale simply because the owner is using FHA financing. That's actually been extended this year to any discriminatory or unlawful purpose. And the change actually adds a right for a person to sue the association if they're blocking a sale on that basis. You're looking at some kind of discrimination claim or something like that, which is always very long and very expensive. So please make sure that you're aware of these requirements.
This affects VA loans also.
Correct. Right, and this is Fannie Mae, Freddie Mac, VA loans, all of those federal loans that come into play.
FHA certification. We have a bunch of associations that apply to get a certification, and it's not required.
It is not required. However, it opens you to more buyers, so you should consider being FHA certified. It's a very meticulous process, so you want to use the association's attorney for it. And another thing that if you are FHA approved, so that, you know, owners can refinance through a federal program or new buyers can use federal funding to purchase a unit. There is always a chance that you can still be marked unavailable. They keep a list of associations that have a lot of deferred maintenance that aren't financially stable. things like that. It's called the unavailable list. Once you get on it, it's very difficult to get off. You can't really figure out if you're on it, except that an owner or a prospective buyer is going to let you know that they can't get a loan approved. So that's why maintenance and repair and all that comes in important. You want to make sure that you're fiscally responsible, which I'll get to in a minute.
Sorry, just generally, like, what is the risk and liability for just not having policies about any of this?
Well,
Well,
not until you get sued.
Nothing until you get sued. Okay,
That's in some ways, I mean,
that's fair.
I'm not being facetious, but
Yeah,
you want to be proactive in terms of following, setting up these policies. The collection policy is one. Now the discrimination sales and so forth. I mean, you just want to list that you have this policy, right?
okay, thank you.
especially government rules and regulations. Yeah, usually it's attached to the rules. It's passed the same way as a rule is by the board. You give notice, litigation notice. And then the board passes it, and it's just usually attached to the rules. Without a collection policy, then the board would need to vote each time you want to turn over an account to collections, unless you have a management agreement that transfers the right to collect assessments to the property manager. Then the property manager makes all the decisions. It's not to require a board vote. Still want to have that policy. That way all the owners know what they have to do.
Next.
The next one is kind of an interesting one. It was just recently passed last year, and it's called the Homeowner Native Landscaping Act. So this applies usually more to community associations, anywhere that an owner has a lot or a place that they can plant townhomes, condos, they're not going to plant, but townhomes, things that they can have flowers or a garden or maintain a yard that is act applies. And what it says is that the association cannot just have a blanket ban on any kind of vegetation that's native to Illinois. Bushes, grass, flowers, any of that, if it's native to Illinois, there's a list, you can check. You can't just ban it. The board still has the right to pass reasonable rules about yard maintenance or even maintaining a garden and things like that. But you can't just say they can't plant them if they have an area.
It's basically, you can't make them.
It's delightful, but so under that, if an owner does do it, they still have the responsibility to keep that area free of weeds, invasive species, and trash. And they also have to ensure that it doesn't encroach on public sidewalks, neighboring property, or the common aspects. So there are some responsibilities and rules, but still, you don't want someone's flowers. Hold on. Okay.
Let's do this sort of quickly. We want to get up. I think it said 9 o'clock, right, Jackie? So we want to leave a little for questions, and I want to talk a little bit.
The last one is the reserve studies. This is actually not active legislation that you have to do. It's pending. CAI Illinois on the committee. We've introduced this a couple of years in a row now. It hasn't got passed, but we're hopeful for the next legislative session. Basically, we want to adopt one to both the Condo Act and SECA. So it would apply to all associations to require them, if they have more than 10,000 at this point, in common expenses. So if you have an elevator, roofs, share things like that, then it would require you to have a reserve study and then update that every 5 years. There's different kinds of reserve studies. But basically, the reserve study is kind of a budgeting and planning tool for the board. You have a study done where a structural engineer comes out to the property and looks up at all those major components, things that will cost more than $10,000 to either repair or replace, elevators, sidewalks, schools, all of those things. And they will tell you actually the lifetime usage, expected usage of that property and when it would need to be either maintained or replaced. And then there's also, they do a financial an aspect to it where they look at the current reserves and then they come up with a plan for the association to how much to expend up to save in reserves annually so that you can meet those future needs without a special assessment or a loan. So reserves are kind of important, like I said. Yes. It helps the board plan for long term without the need of special assessments on everyone, or at least lower special assessments if necessary. It keeps the property in good condition, which makes the owners happy. It will maintain property values because it will attract new buyers. Could even raise property values depending on market. And it satisfies a lot of lender requirements. A lot of lenders do require fairly up-to-date reserve studies so that they can confirm that the association is financially responsible.
So that's kind of an interesting segue. We talked a lot about the collection process and so forth. So I want to segue that because that really does play into this reserve studies. So first I want to introduce the bankers from Community Advantage, which is a division of Wintrust. You guys want to stand up and kind of introduce yourselves?
Certainly, I'm here to I'm on our lending team at Community Advantage. Lending for association. Payers, reserve, contracts, really whatever we're here to assess. So we have.
And I'm Evelyn, I work on the private side, so I'm helping our customers invest their money and their customers to have it turned collect on the escrow.
We also have representatives from the Bank and Trust. So if you guys want to stand up and introduce yourselves.
Yeah, sure. We're Itasca Bank and Trust, basically similar to what they're just no company doing. So a little smaller associations all will go down to state. Loan requests about $100,000 rentals will work for same thing. For management capital.
Your name?
And Don I'm Stelter. So we've been working with associations for and Itasca Bank for about 25 years. You pretty much do all of them for trust.
Well, that's a competition here, right? Okay. So, I want to be brief, but it's important because this reserve study may show up some things that you need to get done over the next 10 or 20 years. And deferred maintenance is not good. So typically they're paid for out of either your reserves, there's a special assessment, or you get a loan. And generally speaking, I would say it's capital projects, roofing, parking lots, siding out here and downtown. You get into risers and water and elevators and all that other stuff. And as we know, elevators are very expensive, right, Nick? So generally speaking, it's kind of the, let's skip this right now. So necessary documents, it's a typical loan. So you get a loan agreement, you get a note. There's no mortgage because what the banks do is they securitize your assessments. So there's an assignment of the assessments. And what that means is if you go into default, the bank can then go in and take your money, which nobody wants to do. And I think generally speaking, associations don't want to get into debt either, but it's a good tool for those projects that you don't have money for, but you need to get done in the near term. So I don't know, do you guys want to talk just briefly about what your lending requirements are for these things? I know you're going to look at delinquencies or assessments that are unpaid for a period of time, what's in collection, what's not, your balance sheet, total amount of your reserves. What else?
Well, each bank has their own underwriting standards. So what Itasca Bank requires for trust versus Fifth they really are customized just like the loan policies in general are. So I can tell you in general what you're expecting. It's really, I think it falls under the heading of responsibility. But delinquency to be under control. That could be, some banks might be 10% of your total units. They might have a cap on total dollars. Some might be 15% between smaller cases, but smaller associations. You might have an association that has reserves. Again, that level can vary depending on the size of the association, the size of the loan. We don't underwrite these loans as lenders any different than we do traditional. I have a part of it's got a very strong balance sheet. You can stay with that. It's under control. Every reserves are a year. It's a property being maintained. It just comes down to, again, the responsibilities.
But typically you want a depository relationship too.
Now, that varies by bank. Some banks require the operating account, some banks require a reserve fund, some others may require it. It all just depends on what's the appetite of that financial institution for the analysis at that.
Right.
And I would add as well, for us, well, one of the things we really look at is also debt to unit value. We're looking at the kind of debt you would have on this project compared to what your unit is worth. We don't have, where we're on 50% of your unit value, it's just this debt, because that just doesn't make sense. And we also would underwrite to 1-to-1 times. Basically what that means is we're looking at after your monthly payment is paid for the association, we still want 10% extra going to reserves. That is just kind of a little bit of a fail safe. If something does come up, you're not fully depleting your reserves. You're not using all of your income to pay for this. We want a little bit of extra as well.
And typically that would be funded either by a special assessment or an increase in the assessments, right?
And then that's the next point. So think about the loans. We don't take real estate. We don't put a mortgage in this. As a board, you're looking to take out a loan. The lender also doesn't want to put the unit in a distressed situation. You get somebody that just purchased the unit, let's say in the next year or two, put 10% down in the unit. The mortgage should be about 90%. The board comes along and says, well, you need to do a special assessment. Special assessment ends up being 30% value of the unit. We might be putting the unit in a position of equity negative. Because the lender pays 90%, the board just had 40%. Then they walk away. And I think it might be important to kind of talk about the difference between operating assessment and special assessment. Because your operating assessment is good because your point special assessment goes by the unit and unit the duration of the special assessment. If you have a unit falls on the special assessment, you have one less person that's rolling the boat.
Right, that's important. Anything else? But that's it's a good tool. I think it's an option for particularly if you have, like I say, special projects, capital projects that are going to go on for a while. Special assessment can be levied over multiple years. That has to be also done as part of your budget process, but all those things kind of play into the reserves that you have to fund the reserves, fund capital projects. You know, if you're a board member, it's kind of a thankless job, actually. You don't get a lot of credit for it. You get a lot of complaints, right? Anyway, I think I was going to touch on some litigation stuff, but we're kind of at the end and probably a little bit over. Happy to answer any questions after we leave, but what I really wanted to cover was fiduciary obligations of the board members. We'll talk about that the next session, but I do want to thank you all for being here. Again, I want to thank Robin. Great job. She is but she is very much involved in the statewide community associations, CAI. She's a board member, and a couple others. We kind of sponsor some things there. So she's done a great job. She's been with us now for 15 years. Yeah, so we stole her from another firm up in Lake Zurich, who will not be named, but she's been with us for a very long period of time. And I think, again, we both appreciate the work that Sam and Jackie have done and Ted in making us an offer we couldn't refuse, right? So once again, thank you very much. fill out the forms. We've got cards up here if you have any questions, and we're happy to stick around for a little while to answer any other questions. So thank you. More food and more coffee.